withdraw. Or can I say that if it's not an arbitration clause in my contract, I can decide to go away with it and go to court straight?
Okay, I understand you've studied family law. Have you studied family law? Have you studied the marriage of Mohammedan Act? Is it monogamous or polygamous? Yes? It's polygamous. When we talk about monogamy and marriages, you wake up. When we talk about ESG, we are chosen. Okay, so when you make a choice that you're going to get married under the Marriage Act, the marriage is going to be civil. You agree that it's going to be monogamous, isn't it? You cannot go into a monogamous arrangement and then you get married to another person. The subsequent marriage will be null and void. It is the same thing between arbitration and litigation. If you make a choice that it's going to be arbitration, monogamous, you cannot have an option of taking part of that dispute to the court. It will be as if you're jumping from the Marriage Act to the Marriage of Mohammedan's Act. Will you ever forget that? So, if you choose litigation as your method of dispute resolution, it is what you choose. And the rationale is that both methods of dispute resolution are final in nature. You cannot appeal against the decision of an arbitrator. You can only go to court to make an attempt to set it aside, or for the successful party to enforce it. The major advantage is that once you go to the court, which is the High Court, for purposes of setting aside an arbitral award, and you fail to set it aside, that's it. There is no room for you to go to the Court of Appeal. There is no room for you to go to the Supreme Court. There is no room for you to go to the East African Court of Justice, the way Marine is indeed. You stop at the High Court. So that's a major advantage. Unlike litigation, then you have to go all the way. You have to go to the Court of Appeal, you have to go to the Supreme Court, and maybe integrated in leeway. You can take some certain questions to Arusha. So that's the major distinction. Over to you.
Thank you. Thank you very much. It's an answer. Now we have a scope of what in East Africa. So you've spoken so highly about arbitration as a preferred form of dispute resolution of energy disputes. And indeed, the ICC recently released the report, their joint task force report on resolving climate change related disputes through arbitration and ADR. And they spoke about so many things. They spoke about the need of getting experts. They spoke about the needs of getting arbitrators who are learned in that field. So they spoke about the need to enhance the law to ensure that we are compliant and that we are ready to actually handle these disputes. So you can see that we're heading in the same direction. So what are the disadvantages? You say that it's final, it's quick, but then it says it's expensive. Someone said in the shallow oil dispute, or one of those disputes, that it's very expensive. But you also say to answer appeal, what if I'm annoyed? What do I do? I'm annoyed, I don't like the award and I have no ground to set it aside. What do I do? But also what the president of Uganda chapter, you also need to tell us what to do to get expertise. When, for example, we leave LDC in August, whenever we leave LDC, and we come to you for an appointment and say, hey, I'm ready, I can handle energy-related disputes, please appoint me as an arbitrator. What do I need to do to develop expertise as an arbitrator?
Thank you, Anne. I chair the Chartered Institute of Arbitrators in Uganda, which is a training institution which was founded in the United Kingdom way back in 1903, and it's the gold standard for training arbitrators. So, a big part of arbitral disputes are resolved through a An example now of an arbitral institution is ICC, the one which has organized this event. So, before the parties appoint you, they must be satisfied that you have the excellence. So after you've done your LDC, we have an institute in Uganda on that training. You can get in touch with us if you want to be certified, if you want to be appointed to resolve the disputes. So the other question you ask is, what happens if a party is dissatisfied? They are not happy with the decision of an arbitrator. Well, we go back to that topic that has made me very happy. Marriage. When you take your vows in a church, there are certain sweet words that you say, for better or for worse. That's how you take on arbitration. You take it with the good things and the bad things. The good things in the sense that you're going to resolve your disputes finally. The bad things, I don't want to call them bad things, that you have to pay the arbitrator, unlike a judge. But if you look at the value of disputes, vis-a-vis the amount of money paid for arbitrator, it's not commendable. You cannot compare it. The other bad thing, which is not really bad, is that an arbitrator can make a decision which a judge may disagree with. For example, an award of damages. An arbitrator can award 100 million, yet a judge feels he should have awarded 20 million. The judge has no jurisdiction to alter what an arbitrator has decided, if they have decided it within jurisdiction. To put it differently, an arbitrator has a right to be wrong if they do so within jurisdiction. Is that clear? For as long as they're within jurisdiction, they have that right. And the judge will not stand on it. But all in all, the fact that arbitration is growing, the fact that we have ICC taking serious step in Africa, there is an ICC conference in Nairobi, there is CRB in Uganda launched in 2023. So you realize that there is growing demand for arbitrators to resolve disputes in Africa. So it has to be we arbitrators in Africa for Africa.
Thank you, so, David, not only are you a seasoned arbitrator, but you have a voice for construction in the industry. You have training on construction law. You know that the ECO project is taking shape. We've been talking about transition, and we've agreed that we are going to transition slowly. And because we are transitioning slowly and gradually, that means we shall still need our pipeline, we shall still need our oil to finance our transition. So, as one of the leading voices in the construction law industry in this region, what are the common construction disputes that you have come across? And what is the preferred mode of dispute resolution? And I think there's a preferred mode of dispute resolution, you can talk about that. But also for other construction disputes, what is the preferred mode of dispute resolution?
Thank you. And this is just to speak to you as lawyers, to show you the opportunities. There was a research which was conducted about construction disputes in the world, but almost 70% of these disputes were in Africa and the Middle East. The research was on 1,800 projects in these countries. And the total value of these projects was $2.2 trillion. But this is where the icing of the cake is. About $100 million